Hello everyone. We are conducting a 4-day workshop on contract drafting. The workshop is titled as the Contract Conjurer's Workshop, that is a Contract Magician's Workshop. We will be speaking about Introduction to the Art and Science of Contracts, followed by Mastering the Basics of Contract Spell, Contract Transformation, Shape Fitting Clauses, Advanced Technique and Advanced Techniques and Practical Applications. So many of you have asked about the demo class, like how the class would be, what can we expect, and so on. So here in this video, I'll be covering a few basic topics that we would be discussing in this said workshop. So let's draft. The first clause that we are drafting today is exclusivity clause. So let us listen what the client has to say. The challenge at hand is to establish and enforce a strict limitation on the distribution, resale, and transfer of a specific software product outlined in Schedule A of an agreement. The primary issue to address is ensuring that the customer complies with these restrictions and do not provide unauthorized access or transfer the software to third parties without explicit permission from the vendor. The problem involves legal and contractual concerns, as well as practical measures to monitor and prevent any potential breaches of these restrictions to protect the vendor's interest and intellectual property. Now, here we can understand that the client is looking for exclusivity here. Now, let us draft an exclusivity clause. It would be read as except as permitted in this agreement or otherwise authorized by the vendor, customer will not supply, sell, resale, transfer, assign, distribute, or otherwise make available to any third party the software or any part of software or of reasonable resemblance more fully described in the Schedule A. Now let's decode this clause that we have drafted. The statement that we are seeing here, that is the exclusivity clause, is a contractual clause typically found in software license agreement. The first part reads that except as permitted in this agreement or otherwise authorized by the vendor. This part of sentence is stating that the customer can only do what follows if it is explicitly allowed in the software license agreement or if the vendor, that is the company or entity that created the software, gives explicit authorization. The second part would be customer will not supply, sell, resale, transfer, assign, distribute, or otherwise make available to any third party the software more fully described in the Schedule A. That is, this part of the sentence lists various actions that the customer is prohibited from doing within the software. First one is supply, providing or giving software to someone else. Sell, selling the software to other party for money. Resale, selling the software again, often at a profit after having purchased it. Transfer, moving the ownership or rights of the software to other person or entity. Assign, legally transferring the rights and responsibilities associated with the software to other party. Distribute, sharing or delivering the software to others. Otherwise make available, making the software accessible for usage or usable by third parties in any other way. In essence, this clause is specifying that the customer cannot engage in any of the listed actions within the software unless they have received an explicit permission from the software vendor through the agreement or separate authorization. This is a common way for software vendors to protect their intellectual property and control the distribution and use of their software. Violating these terms can lead to legal consequence. Now, here, the beauty of this clause is you can see that the software is defined as the software or any part of software or of any reasonable resemblance. That is, ones that are resembling or the software that has similar feature. I hope this exclusivity clause is clear to you. Moving next, we have term that is initial and renewal term drafting. Now here, the problem statement is the current agreement which has been in effect since August 1st, 2019 is scheduled to expire on July 31, 2024 with an automatic monthly renewal mechanism unless either party provides a written notice of their intent to negotiate a new agreement. This problem statement revolves around the need to ensure a smooth transition and timely negotiation of a new agreement. or the potential termination of the existing agreement within the prescribed timeline and in compliance with the terms and conditions set forth in the agreement. It is crucial to address the challenges and the concerns that may arise during this process, including the parties' ability to initiate negotiations, the clarity of notice requirements, and the potential consequences of failing to act within the specified timeframe. The problem statement should seek to identify and propose solution to streamline the renewal or negotiation process and prevent unintended lapse in the agreement continuity. So this is a very lengthy problem that the client has. Now we have to draft this clause in a very few lines and it ensure that it covers everything. So the draft would be like, the agreement shall be effective August 1, 2019 and shall be in effect until July 31st, 2024, and upon expiration shall be automatically extended from month on month in force thereafter, unless written notice of desire to negotiate new agreement in whole or in part is given by either party to the other at least 60 days prior to the next auto renewal date. Now let us understand this particular clause. The statement that we have read above is a legal or contractual clause that outlines the duration and terms of an agreement between two parties. This agreement shall be effective since August 1, 2019. This part specifies the start date of agreement, which is August 1, 2019. It means that the agreement became valid and enforceable on that date and shall be effect until July 31st, 2024. This part indicates the initial duration of the agreement, which lasts until July 31st, 2024. During this period, the terms and conditions of the agreement are binding on both the parties. The third part would be, and upon expiration shall be automatically extended from month on month in force thereafter. After the initial term of the agreement, that is until July 31st, 2024, it will be automatically renewed on a month to month basis. This means that if neither party takes any action, the agreement will continue on a month on month basis without the need to sign a new agreement. Fourth part is, unless written notice of desire to negotiate a new agreement in whole or in part is given by either party to the other at least 60 days prior to the next auto renewal date. To stop the automatic renewal or make changes to the agreement, either party must provide written notice expressing their desire to negotiate a new agreement. This notice must be given at least 60 days before the next auto renewal date, presumably July 31st, 2024 for the first instance. So here we can understand that this clause is a perpetual clause. That is, the contract does not end on July 31st, 2024. It will be ending only after the vendor gives a 60 days notice prior to the next auto renewal date. In summary, this clause establishes the initial term of the agreement from August 1, 2019 to July 31, 2024 with automatic month-to-month renewals. Thereafter, unless either party provides written notice to terminate or negotiate a new agreement at least 60 days before the next auto renewal date. I hope this term, that is initial and renewal term, is clearer to you. Moving next, we will be drafting the last clause of the day, that is compliance clause. Here, the problem statement reads as, the parties have entered into an agreement that necessitates strict adherence to various legal requirements. The parties must continuously comply with the laws relevant to the agreement, their respective business operation, and the fulfillment of their rights and obligations under the agreement. These laws encompass a wide range of areas, including but not limited to import and export regulations, environmental protection, health and safety standards, labor and employment laws, hazardous waste management, and intellectual property rights. The problem at hand is to establish and monitor and ensure comprehensive compliance with these laws throughout the duration of the agreement to prevent legal complications, regulatory violations, and potential disputes that may arise in non-compliance. Now, here this is understood that this is a compliance clause and this would be drafted as, the parties shall at all times comply with laws applicable to this agreement. Each party's operation of its business and the exercise of its rights and performance of its obligation hereunder, including but not limited to laws related to import and export, environment protection, health and safety, labor and employment, dangerous waste processing, and intellectual property. This compliance clause outlines the requirement of the parties involved to adhere to various laws and regulations. Here is a breakdown of its meaning. To start with, what is compliance? Compliance refers to the act of following and adhering to certain rules, laws, regulations, or standards. The parties. The parties likely refer to the individuals or entities entering into the agreement, such as a contract between two companies. Shall at all times comply with all laws means that the parties are obligated to follow all applicable laws and regulations consistently and without any exception. Applicable to this agreement suggests that the parties must follow the laws and regulations that are relevant to the terms and conditions outlined in this specific agreement. Each party's operation of its business indicates that the compliance requirement extends to the general operation of each party's business. The exercise of its rights and performance of its obligation hereunder. It emphasizes that the compliance obligation applies to all actions, rights, and responsibilities outlined in this agreement, including but not limited to laws related to. This is a very important line because this one you will find in almost all the contracts and many of the clauses. So, this is an indication that the following list is not exhaustive and that there are maybe other laws and regulations that are applicable. The list of specific law includes import and export laws pertains to the rules governing movement of goods across the international borders. Environment protection law encompasses regulations related to protecting the environment, including issues like pollution control and conservation. Health and safety laws refer to regulations ensuring the health and safety of the employees and others in the workplace. Labor and employment laws, including laws related to employment, labor rights, and workplace condition. Dangerous waste processing laws relates to the proper handling and disposal of hazardous waste material. Intellectual property law encompasses laws concerning patents, trademarks, copyrights, and other forms of intellectual property protection. In summary, this clause in the agreement requires the parties involved to adhere to a wide range of laws and regulations which are relevant to their business operations and the terms of the agreement. Failure to comply with these laws would result in legal consequences. So here in this demo session, I have drafted three major clauses which would be present in majority of the contract. That is exclusivity clause, term, that is initial and auto renewal term, followed by compliance clause. I hope you found this video informative and I'm very much eager to meet you in this workshop which is scheduled for the 4 days. If you have any questions or if you need any more details about this workshop, please feel free to connect in the provided number via WhatsApp.